And welcome to another edition of LCP Talks. And LCP stands for the Legal Center for Palestine. We're based in Canada. My name is Bill Skidmore. I'm a member of the board of LCP, and joined today for discussion is Emilio David, also a board member. Specifically, we're going to talk about a motion to strike in a particular case that LCP, together with other legal bodies and lawyers, has been working on pertaining to the Canadian government's role related to the genocide in Gaza. But first, Emilio, hello, welcome. Again, we talked a few weeks ago about the case. I'm going to just very quickly summarize it a bit and then ask you to summarize. The case is Hani E. Bat-Nigi and Tamar Gerarda versus the Attorney General of Canada. LCP is working on this case with Coalition for Canadian Accountability in Gaza. And this involves, besides LCP, the Canadian branch of the International Center for Justice in Palestine, as well as Dimitri Lascaris Law and Yaver Hamid Law, two independent lawyers who work on this as well. So welcome, Emilio. I want to go to the factum related to I won't say much about the motion to strike at this moment, but just from the factum where you're responding from the government's asking for a motion to strike, let me just read a very short paragraph and ask you to elaborate on the case itself that we've been working on for, gosh, I don't know how long, a year and a half. In paragraph 3 of the factum from our side, it says the claim raises two fundamental questions. One, did Canada fail to fulfill its common law duty to take all reasonable measures to prevent genocide? And of course, we're talking about the Israeli genocide in Gaza. Secondly, did Canada, whether through that failure or otherwise, the failure to take all reasonable measures, did Canada, whether through that failure or otherwise, contribute to violations of the plaintiff's rights under sections 17 and 15 of the Canadian Charter of Rights and Freedoms? Article 17 is the right to life, liberty, and security of the person. Article 15 is about equality rights under the law and the prohibition of discrimination. Briefly then, could you tell us, the listeners, what is this case about? What are its fundamentals?
Yeah, thank you. Thank you, Bill. The case is Hani Al-Batniji and Tamer Jarada versus Attorney General of Canada, right? And in this case, basically, the lawyers working for this Coalition for Canadian Accountability in Gaza, in their submission, in their statement of claim, we are making effectively two main arguments. Is that that Canada violated basically its obligations to prevent genocide, and that by failing to do so, Canada also violated charter rights of our clients. Now, what are we asking from the court? A declaration in that sense. And what is the objective of obtaining this declaration? We believe that such a declaration, with the authority of a decision made by the court, could help us to facilitate the commencement of other kinds of actions related to the role of Canada and Canadians in the genocide in Gaza.
Okay, so that's a good brief summary. Thank you, Emilio. Now, the key point for today, we're talking about in response to this case and the allegations it makes, the Canadian government, through the Attorney General of Canada, submitted to the courts what's called a motion to strike. And lawyers will know what that is. Most of us who are not lawyers, this will be new terminology, perhaps. So could you, two things here. What is a motion to strike? And secondly, what has the Attorney General of Canada argued in its motion to strike with reference to this case?
Yeah. Well, a motion to strike, very simply put, is a formal legal request within legal proceedings, right? Legal proceedings have been initiated in some way, and the defendant can, in some cases, respond by a first move, which is a motion to strike. So the motion to strike is a formal legal request made to a court to basically dismiss a case. Why that can be asked? In different cases, it can be asked. Basically, the main argument being that the legal action initiated does not have a reasonably valid course of action, that it does not have any expectations of success, and that actually in a certain sense, the action is a loss of time for the court and for the justice system. And now, this motion to strike, the legal request to dismiss a case from the outset, can be asked in whole or in part. And the Attorney General in this case is doing both. Is asking the court to completely dismiss the legal action, because in their opinion, the legal action first does not have any reasonable expectation to succeed or course of action, a legal course of action. And in the case the court decided not to strike our submission, they are asking for at least the court to strike parts of it, because they argue those parts are scandalous.
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 Is that a typical legal term?
It's a legal term. It's
Yeah.
a legal term within the rules that regulate motions to strike. You can strike parts of a pleading that are, according to these rules, scandalous. And scandalous means unnecessary, unuseful, destructive, that are put there only for color.
What does that mean for color?
Only for with the intention of making the pleading more appealing, subjectively, or simply because the pleading is insulting in some parts.
Insulting.
Yes.
What that sounds
you can imagine, pleadings where a part treats the other part in ways that are completely unnecessary for legal proceedings, like attributing to the other part, outrageous intentions and things that are not proper to the procedural step in which we are. We will see whether the court agrees with the Attorney General's position, and we will take it from there. We have foreseen all possibilities, and we are prepared to act accordingly. Now,
just let me interrupt you for a second,
yeah,
Emilio.
Yeah.
Eventually I'd like to get, how you have responded, how the coalition has responded. But I have to say, I've read the case, your position that you introduced in the case, in the factum. And it just finds me, to me, it's very interesting to suggest, it won't succeed, it's not strong or whatever, and therefore asking for it to be dismissed. Because the case, there's the coalition and the four bodies of the coalition that are part of that, but it also is built on a tremendous amount of research. It's not just casually issued allegations. It's based on very serious research about the law, about case history, about the actual conditions in Gaza, documentation from other legal bodies. Uh, so I'm curious, for them, the government to actually say, oh, it's almost like saying it's frivolous, it doesn't have a chance to succeed. Whereas I assume generally the court should decide through a fair hearing of the evidence and a response to that evidence, whether it has a chance to succeed or not. So tell me, okay, you've received the motion to strike, and you will be defending against that. What could you summarize or give the major arguments against what the Attorney General has put out in the current objection to the trial going ahead by issuing a motion to strike?
Right. So first to your comment before, actually, I think is very important. To be fair to the position of the defendant here, the Attorney General, yes, our legal case is based on tremendous work on legal research and factual evidence and etc. But here in the motion to strike, it doesn't matter how well grounded our legal action is in facts, because here we are just discussing legal questions. And the legal question is whether this action that we initiated has a reasonable expectation to succeed or not. Now, their argument is basically to say that it doesn't, that this action does not have any reasonable expectation to succeed. It does not have a legitimate or legally valid course of action. And what do they mean by that? Well, they mean that, according to what they say, that the questions that we are asking to the court, so they say, are not justiciable, are not basically a matter that a court can decide. Why? Because we are asking the court to pronounce itself on questions that are eminently political questions, that are related to powers that are proper and exclusive of the executive branch of the government, namely foreign policy and the state reaction to allegations of genocide and other international obligations. And therefore, they argue, since the questions being asked in the statement of claim that we initiated to the court are not justiciable, are not questions on which the court can pronounce itself, because they are either because they are eminently political questions, or because that could constitute an illegitimate interference from one governmental power into the prerogatives and powers of another government power, meaning the judiciary and the executive. This is basically their argument. Actually, what the government intends with its motion to strike is actually to prevent altogether the discussion on facts.
So the foreign policy is the arm of the executive branch.
Right.
Does this argument lead to the notion then that the executive branch is above the law, that it can do whatever it wants and the courts are not entitled to assure that its actions are in accordance with law?
Right. It's exactly our argument, right?
Mm-hmm.
But before that, Bill, if I may, just to finish with their motion to strike. So
Mm-hmm.
the main argument of the motion to strike is that there is no a foreseeable, legitimate, or valid course of action because the questions that are being asked to the court are non-justiciable. And so it's useless, they say. It's useless that the court pronounce itself on these matters. Why would you do it if it will not lead anywhere? And anyways, and this is the second part of their argument, is that first they argue that there is no violation of charter rights. Because most of the alleged violations of charter rights can only be attributed to the state of Israel and not to the state of Canada. That actually our clients were affected by the actions of the state of Israel, and there was no causal direct link between the actions or omissions of Canada and the prejudice or the violations of our clients' rights. This is the second part of the motion to strike.
But yet, looking at your original submission, and even the subsequent one in response to the motion to strike, you don't you show how the Canadian government itself has responsibilities which it has failed at.
Right. I mean,
So,
our argument is precisely this one. So, to this motion to strike, we responded already, and we are having the the oral hearings on the 27th of November. The court will hear our pleadings so very soon. And our response to the government in motion to strike, particularly regarding the first part, on the argument that there is no foreseeable course of action or any expectation of success for this legal action, and that therefore, on this basis, it should be struck down. To this, we are basically responding by an argument that seems to be quite evident, twofold, I would say, is that we are actually not asking the court to pronounce itself on the decisions that the government makes in terms of foreign policy. We are not asking the court to say how the government should act. We are not asking the court a political question about whether the ways in which the government performs its foreign policy are reasonable or politically sound. No, we are asking the court to pronounce itself regarding a legal obligation of the Canadian government. It's a common law obligation, meaning it's a Canadian domestic law obligation of the Canadian government to whatever it does in terms of foreign policy, right? It needs to make sure that this is done according to the law and its legal obligations. Of course, the government has an exclusive power to decide foreign policy, but within the legal frame. And this has been discussed in Canada for a very long time. And the courts, to make it very simple, the courts have always maintained, for many years, the courts have maintained that discretion that the concept of discretion, which is what the government has, the executive branch has in regard to foreign policy, it has a discretionary power, while the courts have been unanimous almost in upholding the idea that discretion is not a synonym of arbitrariness. That the government has discretion on certain matters, that the executive branch has discretion on certain matters, say the courts, does not mean that the government can act arbitrarily or illegally, you see.
Are you asking the courts to both rule on past actions, let's say from October 7th, 2023, the Canadian government, as per what the plaintiffs are alleging, so what has happened since then, but does it also perhaps will result, if should it go favorably for the coalition's side, instructions of how it must act, what its legal obligations are going forward as well, both the past, what it has done wrong, and what it must do in the future?
No, actually, for reasons that we can discuss, this case is not about asking the court to tell the executive branch how to do the work of foreign policy. We are not asking the court to tell the government how to act, which we could possibly not do so, and the court could not do so. No. We are not asking the court to order the government anything. We are asking the court to say the law, and whether, according to the law, Canadian law, the government has violated its common law obligations to prevent genocide, and second, if by doing so, by violating its obligations to prevent genocide, whether the government has also violated charter rights of our clients. You see, we are asking the court a declaration of the law. This is a purely legal discussion, and the government is adamant in framing it as a political question.
So this, if you were successful in the case, this will put additional pressure on the Attorney General based on what the findings of the judges are, to in fact enable certain cases. But of course, the Attorney General, who's also the Justice Minister, is a member of the federal cabinet. And this is perhaps not so much a legal question as a political question. What are the chances, do you think, that a member of cabinet, as the Attorney General and Justice Minister, number one, would move on that, given it may result in their expulsion from cabinet? And is that a possibility that an attorney, the current Attorney General, let's say Sean Fraser, could act correctly, but then be replaced by a subsequent Attorney General who knows they have to reject any cases that come to them regarding accountability for what has happened during this genocide in Gaza?
Well, Bill, this is something that we cannot foresee or predict, the ways in which the Attorney General will act. This is a test. This is a test. And given the behavior of Canada, the Canadian state, towards Israel, protecting, arming, financing, legitimizing, diplomatically protecting it, etc. We don't expect to have very friendly ears in any of the state authorities in Canada. So if the Attorney General declines, we will simply challenge his decision, because again, the discretionary power that the Attorney General has on these matters should not be translated or understood as the capacity or the power to act arbitrarily or against the law.
Exactly. That's the point you made early on in this discussion.
We are prepared to challenge whatever decision, but you understand that how a declaration, in this case, a declaration by a court, would not only make more difficult for the Attorney General to simply decline his consent, but it would put us in much better legal standing to do what we are planning to do, which is to open a series of other legal cases.
So there still remains this hurdle, and I'll go back to the motion to strike. Getting through that, what?
Sorry, Bill, can I say one more thing about
please,
that?
Go ahead, of course.
But because my point was twofold, actually. First, yes, we may lose, but we will challenge these decisions, and we will fight it until the end. Legally speaking, this is what we can do. These cases have also a very key political importance for us. Is we want those people on the record tell us what was your position regarding war crimes, crimes against humanity, and genocide that was when the genocide was taking place in Gaza. We want you on record for history books, for political debates, right? To know the position of the Canadian state. So you see, for me, it has, of course, important legal implications, particularly for our clients, but also politically and symbolic implications that one should not completely dismiss.
Okay, but here to be clear, you're talking about not the motion to strike results, but the results should the case go forward and be heard in its completeness. Well, if we look at the duty to prevent genocide, the lack of actions by the Canadian government to do anything other than issue statements, not to impose sanctions, not to cause diplomatic pressures and other pressures that would actually be substantial, economic particularly. They failed in that regard. So there would still be a push on those questions. But to get to that point, what if I'm imagining here? So the hearing, you said, what is the date? November
27.
27. Should the judge rule that, I assume if they rule against the Attorney General in the motion to strike, that the case will continue and we're back on track with what you were saying. What happens if the judge agrees with the request of the Attorney General, the motion to strike the case? What then are the options of the coalition to move forward?
If the court accepts the arguments of the motion to strike, you mean?
Yes.
Well, we would have to appeal. We would have to appeal.
Okay, so that would continue. Is there any court that you can appeal to outside of Canada, should the motion to strike be successful?
Well, thank you for asking that, Bill, because this is something that relates to the importance of this action. Because I told you this action is important in itself, right? To restore the rights of our clients first, right? Second, is important because if we succeed, well, that puts us in a very different legal standing to initiate other cases for various forms of accountability. But third, and this is related to your question, is that we clearly have the intention of resorting to international courts if it is necessary. And international courts, like the ICC, for example, they have complementary jurisdiction, meaning that to go to the ICC, from Canada to go to the ICC, you need to first exhaust all legal means available in your jurisdiction, meaning in Canada. So this is a legal requirement too, to go to the ICC and other international courts and instances, is that you exhaust domestic legal means. This is also one of the things that we are doing here. So if we don't find reparations and remedies within Canadian jurisdiction, and we have exhausted all our legal means, then yet we would have stronger standing to go to the ICC and other international courts. Yeah.
Well, you said the ICC. What might the other international institutions alternatives be?
Well, I prefer not to disclose that. I think for strategic reasons I should reserve that.
Yes.
But you know, I mean, a case that I don't mind disclosing is a possibility of holding Canada accountable for its violation of for the violation of its legal obligations to prevent genocide in the ICJ. In which case, we need a state to action against Canada, like in the case of, if I remember well, Nicaragua versus Germany, right?
Yes.
That is a possibility.
Okay.
That we are also studying.
Well, you know, hopefully it's not going to have to go to that. When you talk about exhausting all options domestically, it is exhausting, both not only for you know, in the way you use the word, but for the plaintiffs, for the lawyers, for the coalition working on this, and it's so long term. Courts drag on as the killings continue and the devastation is there. But it is the necessary road you have to follow legally.
Now, let me tell you something to finish. Is that, you know, what I find particularly shocking in the government's pleadings, in their motion to strike, and in their notice of motion to strike, they have consistently used words such as scandalous, abusive proceedings, unnecessary backgrounds, etc. So when you say that certain allegations are absurd, that are scandalous, that etc., etc., I mean, I ask myself, what is that you really mean by that? Is that the Canadian government cannot commit a crime, or that the Canadian government cannot violate its international legal obligations? I find that position very problematic, actually, and reflecting something that we are denouncing in our pleadings, which is a form of anti-Palestinian racism, right? Because basically what the Canadian government is telling us is that actually, by definition, it is absurd to think that Canada or the Canadian state has violated its legal obligations, or that it's absurd to think so. That is an abuse of procedure to even claim that. So I see two things: anti-Arab, anti-Palestinian racism, but also a certain form of white supremacy. It seems that, you know, Canada has never been shy in denouncing crimes and violations of international law by other countries, particularly in the global south, in Syria, in Russia, in the Arab world, but also in Latin America, they don't seem to have a problem with denouncing state crimes elsewhere. But when it comes to Canada, right, they seem to adopt a position that consists in saying basically that arguing, claiming that the Canadian government could have violated its international law obligations or participated in a crime is absurd, obscene, scandalous, without any grounds. So the question is, what do you mean? Is that by definition the Canadian government? So you are putting yourself in a moral standing that is beyond the standards that you apply to other.
You know,
To
Emilio, it
other.
sounds so much like Israel's approach,
Absolutely,
that
absolutely,
they are not capable of committing crimes, that they are somehow more moral, noble. And so
absolutely,
it's an absurdity to suggest that there's a genocide or any kind of war
absolutely.
crimes.
So what I perceive in the position of the Canadian government is some kind of moral pedestal. I don't know if
Yes, I understand that it is above others. It is pure.
right, that it would be absurd, obscene, scandalous to even claim that they
Yes,
could have been participating in something like that, which
yes.
is a completely ahistorical claim, right?
But it goes along with notions of being the civilized
Absolutely,
and bringing to
absolutely,
the world all light and good. And
absolutely,
how could you claim that we could act otherwise? And it's a mythology, sadly, that permeates, I think, as a personal opinion, permeates our society. Uh,
absolutely.
I grew up with that, as a young child in the 1960s, Canada, which was then primarily, almost exclusively, not counting Indigenous people in terms of people from elsewhere, overwhelmingly white, and
Yep,
growing up with notions that we know how to do things better. And the
absolutely,
reason we're rich and the global south is poor is because of our industry, our smarts. And it was also, at that time at least, linked to religion, a belief in having the true
right,
faith, on and on. And so we're seeing the vestiges of these belief systems uh, coming out in terms of how the Attorney General is responding to claims of Canadian Canada, the state, violating its obligations under international law.
right,
Okay,
right.
so Emilio, we kept you for a long time. So you're always
Thank you,
wonderful
Ali.
to have on and
Thank you,
talk
you,
to you,
Bill.
and
Thank
your
you very much.
engagement in really, and I think you've explained well
I
why
hope so.
this legal case will have long-term effects despite the obstacles being thrown in its way.